Hello students and welcome to the lecture. So students, as we know that we are covering the Panchayati Raj, okay? And basically in these are the topics we have scheduled for the discussion, like starting with the introduction part, then the evolution of the Panchayati Raj, thereafter the 73rd Amendment Act of 1992, thereafter the compulsory and the voluntary provisions, thereafter the PASA Act of 1996, thereafter finances of Panchayati Raj, and then the reasons for ineffective performance. All right. Out of this, we have completed the introduction part, evolution of Panchayati Raj, and we have been discussing upon the 73rd Amendment Act of 1992. The topics we are left with is the compulsory and the voluntary provisions, the PASA Act of 1996, the finances of Panchayati Raj, and the reasons for ineffective performance. Okay, so that's the picture we have created all together so far. So we will start from where we had left in the previous lecture. Okay, like these are the things we have discussed about the 73rd Amendment Act of 1992. Okay, and basically we had discussed that the reservation part for the SC and ST is not applicable to the state of Arunachal Pradesh. Okay, we have discussed the you can say reason behind it, like inhabited fully by the indigenous tribal people. Okay, and basically we had discussed that there was an 83rd Amendment Act of 2000 which provided this provision. Okay, so that is what we had discussed in the previous lecture. Now what we are going to do, that we are going to see the duration of panchayats, but before this let me ask you one thing. What is the election scenario for the members of panchayat and for the chairperson of panchayat? Like what is the type of elections they have? For this you have only 20 seconds to think an answer, then I will provide you the answer. Your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, and 20th. So basically, the members of Panchayat at all level having the direct elections. Okay, the chairperson of Panchayat having the indirect elections. Okay, that's the thing. For the members of Panchayat, for the chairperson of Panchayat. Okay, now let's have a talk over the duration of Panchayat. The Act provides for a 5-year term of office to the Panchayat at every level, where it is a Jila Parishad, Block Samiti, also known as Panchayat Samiti, and the Gram Sabha or the Village Panchayat. However, it can be dissolved before the completion of its terms. Further fresh elections to constitute a Panchayat shall be completed first before the expiration of its duration of 5 years. What does it mean? Suppose if the elections were made in 2001, so the Panchayat shall continue 2006. It means that the election should be had after 2006 or in 2006, which means after the completion of the term, right? That's the thing. But the acts provide that the election should be, you can say, held not after the completion of the term, but before the completion of the term. So maximum the elections will be had till 2005. So that's the thing, before the expiration of the terms. Second case, in case of dissolution before the expiry of period of 6 months from the date of its dissolution, it means that you can say before completion of the term for 5 years, somehow the panchayat was dissolved. It means that within the 6 months from the date of dissolution, the fresh election should be made. Okay, that's the thing. But where the remainder of the period for which the dissolved panchayat would have continued is less than 6 months, it shall not be necessary to hold any election for constituting the new panchayat for such period. It means that suppose in January 2001 the elections was held, so the panchayat should continue till December 2006. Okay, that's the thing. But there is a condition that suppose if the elections was you can say held till July 2006, then the elections will be valid elections. Why? Because there are total 6 months before the completion of the term. But if the elections are scheduled to be happened in September 2006, then the elections will be declared as invalid elections. Why? Why invalid elections? Because there are less than 6 months before expiration of term. Less than 6 months before expiration of term. Okay, that's the thing. All right. Let's move to the next point. Moreover, a panchayat constituted upon the dissolution of panchayat before the expiration of its duration shall continue only for the remainder of the period for which the dissolved panchayat would have continued had it not been so dissolved. What means that suppose if that was the time period, okay, from January 2001 to January 2006, if that was the time period, okay, it means that the panchayat should continue till here. But what happened that you could say in September 2005, due to some reasons, panchayat was dissolved. Okay, then what happened? That the new panchayat, suppose the new panchayat came into the office in 2006, which means that they should continue till December 2011. Okay, for the time period of 5 years, right? But that is not happen. That is not happen. What does it mean? It means that the new panchayat, which would be constituted after the previous panchayat was dissolved, not completed the term. Remember what I'm saying. They dissolved, not completed the term. Okay. So whatsoever the new panchayat will be constituted, the new panchayat will only have the right to continue till the previous panchayat would have continued if the previous panchayat was not dissolved. Okay. So it means that instead of continue till December 2011, the new panchayat will only continue till December 2006. It means that the time period instead of 1 year, sorry, instead of 5 year will only for the 1 year. Okay. So that's the important thing. Please keep this thing in your mind. So you could say, in other words, a panchayat reconstituted after the premature dissolution, which means that the panchayat would have not completed the given term, does not enjoy the full period of 5 years but remains in office only for the remainder of the period till the previous panchayat would have continued. Okay, that's the thing. So that is about the duration of panchayat. Now, what are the basis for the disqualifications? Okay, like on what basis the person could be disqualified for being the member and the chairperson of the panchayat. So basically, the first provision is a person shall be disqualified for being chosen as or for being a member of panchayat if he is so disqualified. Okay, it means that the person who got disqualified by the provisions of the 73rd Amendment Act of 1992, the person will automatically disqualified as being a member of panchayat. Okay, that's the thing. So the first ground for disqualification is under any law for the time being in force for the purpose of election to the legislature of state concerned. It means that when the elections were happening or when the panchayat was continuing, if state pass any law through which the person who is participating in the election is getting disqualified, then the person will automatically disqualified. Got it? Thereafter, under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21. Further, all questions of disqualification shall be referred to such authority as the state legislature determines. Okay, which means that if the person is below the 25 years but he has attained the age of 21 years, then he is eligible to be the part of panchayat elections. Okay, and thereafter all the questions regarding the disqualifications, they shall be referred to such authority as the state legislature determines. Okay, so basically it is state legislature's discretionary power. Okay, thereafter the state election commission. What does it mean? The superintendence, direction and control of the preparation of the electoral rolls and the conduct of all elections to the panchayat shall be vested in the state election commission. It consists of a state election commissioner to be appointed by the governor. Alright, now I'm going to ask you a very simple question, which is that I had told you about the Election Commission of India, right? I had told you about it. Now you're required to tell me that Election Commission of India look after election of which offices? You have 30 seconds to think an answer. Then I will provide you the answer. So your time starts now. 30 seconds you have to think an answer. 10 seconds finish. Last 20 seconds left. Last 10 seconds. Okay, the time's up. First, they look after the first is parliamentary elections. Thereafter, presidential elections. Thereafter, state legislature elections. And the fourth is the vice presidential elections. Okay, so these are the domains in which the Election Commission of India participates. Okay, now come to the State Election Commission. So the State Election Commissions is basically having the power for the superintendents to give directions and to have the control of preparation of electoral rules and in charge of conduction of all elections to the panchayat. Okay, and the State Election Commission having the State Election Commissioner who is appointed by the governor of that particular state. Okay, and members of the Election Commission of India is appointed by whom? Appointed by the President of India. Got it? That's the thing. His condition of service and tenure of office shall also be determined by the governor, shall not be removed from his office except in the manner and the grounds prescribed for the removal of the judge of the state high court. Okay. His condition of services shall not be varied to his disadvantage after his appointment. It means that once the state election commissioner is appointed, his service conditions could not be altered or changed till the completion of his term. Thereafter, the state legislature may make provision with respect to all matters relating to the elections to the panchayat. Okay, it means that the state legislature having the powers regarding the provisions making. Thereafter, what are the powers and the functions conferred by the act to the panchayats? So basically it's on the state legislature, like the state legislature may endue the panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government. It means that basically it's depend upon the state legislature, like which powers they wanted to provide to the institutions of the panchayat so that they could exercise their powers as the self-government. Such a scheme may contain provisions for the devolution of powers and the responsibility upon panchayat at the appropriate level with respect to these two areas. First, the preparation of plans for the economic development and the social justice. Third, the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 29 matters listed in the 11th schedules, and these are provided by 73rd Amendment Act of 1992. Okay, that's the thing. All right. Thereafter, what are the finances powers? The state legislature may first authorize a panchayat to levy, collect, and appropriate taxes, duties, tolls, and fees for their respective regional areas. Thereafter, assign to a panchayat the taxes, duties, tolls, and fees levied and collected by the state government. It means that first they having the right to impose their own taxes, levy them, collect them, appropriate them. Taxes, duties, tolls, and fees for their regional areas. Thereafter, the state government could authorize the panchayat to having the share in the taxes, duties, tolls, and the fees which have been levied and collected by the state government. All right. Thereafter, Part C, provide for making grants in aids to the panchayat from the consolidated fund of the state. Okay, and provide for the constitution of funds for crediting all monies of the panchayat. It means that whatsoever the collections the panchayat will make, this could be constituted in the funds which would be created by the state government so that the panchayat's money could be stored at a well-defined area. All right, that's about the finances. Now, the finance commission. What about it? The governor of a state shall, after every 5 years, constitute a finance commission to review the financial position of the panchayat. Like the finance commission, which is constituted at the state level, sorry, at the national level. Similar type, the state finance commission constituted for the state level, and basically they having the task to review the financial position of the panchayats operating within the state. Okay, and they having the right to make the following recommendations to the governor. And the finance commission appoints at national level to whom they made the recommendations, to the president. Okay, then the president presented the recommendations to the parliament for the discussion. Okay, so the principles that should govern here is that first, the distribution between the state and the panchayat of the net proceed of the taxes. What is the net proceed? Again, I'm telling you, total amount collected subtract from total expenditure occurred. Total amount collected subtract from total expenditure occurred equal to total net proceed. For example, suppose if the total collected amount was 10,000 crores. Okay, and the total expenditure occurred was rupees 1,000 crores. So 10,000 minus 1,000, total 9,000 crores is the net proceed. All right, that's the thing. So how does the distribution should be made between the state and the panchayat of the net proceed of the collected taxes, duties, tolls, and fees levied by the state, and allocation of shares amongst the panchayats at all levels. Okay, that's the thing. Thereafter, second point is the determination of taxes, duties, tolls, and fees that may be assigned to the panchayat. Okay, like which taxes, duties, tolls, and fees should be assigned to the panchayats and which should be retained by the state government. All right. Thereafter, the grants in aid to the panchayat from the consolidated fund of the state. It means that what should be the manner of this. Thereafter, second is the measures needed to improve the financial position of the panchayat, like what measures could be acquired so that the financial position of the panchayat could be elevated and could be improved. And the third point is any other matter referred to it by the governor in the interest of sound finance of the panchayat. On that matter, the you can say the state finance commission could send the measures. Thereafter, the state legislature may provide for the composition of the commission, like what should be the composition of the commission, what should be the required qualification of its members, and the manner of their selection. Okay, so that basically depends upon the discretionary or state legislature. Okay, so here after seeing this, you could conclude that the state finance commission having the very much similar working like the finance commission of India, but the only difference is the finance commission responsible to the parliament, to the president, and at the national level. The state finance commission responsible to the state legislature, the governor of the state, and basically at the state level. Okay, so students, basically in this lecture we have completed till here. In the next lecture we will continue from here. Till then, just revise the all the facts and figures whatever we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and thank you.